Welcome everyone. This is the final presentation of the February 2025 bootcamp. My name is Andrew. I'm the founder and owner of IBIS Prep, and I am so pleased with the performances of my students so far and more confident than ever for the results that we're going to see when they come out in April. We just had Meryl Blau, a Mind Power coach, give us some really great advice, and overall, she talked about visualization. Visualize yourself getting the answers right. Visualize yourself writing outstanding essays. Visualize yourself after the bar exam at American Social with me, having a drink, celebrating an amazing performance, right? We want to visualize success and visualize an amazing future. But in the meantime, we have to take care of the details, right? The devil is in the details. If you take care of the details, everything else will take care of itself. So I'm going to go over some details with you all right now. And the things I'm going to talk about are going to be tested on the UBE, tested on Florida, tested on California, tested on the MBE, tested in general, mostly federal law that is applicable for every single exam, main conceptual ideas that we need to understand. And if you understand them, maybe you'll do amazing on test day. Let's start with contracts. So contracts, if you're writing the essay, we think of buy friends drinks, big drinks. Don't listen, buddy in kindergarten. I'm talking about apple juice here. Buy friends drinks, big drinks, body of law, formation, defenses, breach, and damages. Body of law, UCC versus common law. UCC is for goods and common law is for services or land or things of that nature. After body of law, we're going to talk about contract formation, offer, acceptance, and no consideration. Offer is a manifestation of intent to be bound by a contract, which gives the power of acceptance and the offeree. Acceptance is intent to be bound by those terms with mutual assent and a meeting of the minds. And consideration is a bargain for exchange, doing something that you were not legally obligated to do before. So a bargain for exchange of value or detriment. At common law, we have the mirror image test, which means that the terms of the acceptance must match the terms of the offer exactly, or it constitutes a counteroffer. The UCC is a little more liberal with the battle of the forms provision, where an additional term that's in the acceptance will be included in the contract. It's going to be a contract that's formed, and the additional term will be included unless it materially alters the contract. If it materially alters the contract, it's a conflicting term under the UCC, it'll be knocked out, and we'll use UCC gap fillers to determine what the case will be. My man in kindergarten is locked in paying attention. I like this right now. The kid's going to law school. Okay, so when we have this conversation about contracts, we have body of law, contract formation, offer acceptance, and breach. Offer acceptance and no consideration. And we also want to consider UCC is going to be the battle of the forms provision. Common law is going to be the mirror image test. But what about performance? Performance under the UCC is the perfect tender rule. Performance under the common law is going to be substantial performance. So a good way of thinking about it is it's more liberal when we're talking about formation under the UCC, but it's more strict when we're talking about delivery under the UCC. It's the opposite. For common law, it's more strict when it's talking about formation with the mirror image rule, but it's more liberal when it talks about performance under substantial performance test. So really orient yourself common law versus UCC and understand what the ramifications may be. So body of law, formation, and then defenses, the statute of frauds, contracts that are over $500, contracts that are in contemplation of marriage, contracts that are for land, contracts that cannot be completed 1 year, executorships, suretyships. These all need to be in writing and signed by the party to be charged. Some exceptions would be specially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. Other defenses to contract formation or execution include mutual mistake, unilateral mistake, fraud, duress, misrepresentation, illegality, incapacity, which could be intoxication or infancy, an illusory contract, which is like an empty promise, illegality, impracticality, and frustration of purpose, latches, acquiescence, unclean hands. These are all different types of defenses to contract formation and execution. If a contract is formed, then the contract could be breached. It could be material or immaterial breach. And then we're going to look at damages. In contract law, we have legal relief and equitable relief. Legal relief is monetary. So it's like expectation damages to put the non-breaching party in the position they would be in if the contract was performed, or consequential damages, which are foreseeable in light of a breach. Also incidental damages, which are recoverable to mitigate the losses for recovering for the breach, let's say. There's also restitution to disgorge ill-gotten gains, reliance damages under theory of promissory estoppel, detrimental reliance, lost wages, lost profits, nominal damages, liquidated damages, which are damages contemplated in advance because they'd be too speculative in light of a breach, and they must be reasonable and cannot operate as a penalty. Equitable relief includes specific performance, injunction, reformation, rescission, quasi-contract, promissory estoppel theories. These are different forms of equitable court-ordered relief. Some other concepts that we could see tested in contract law: accord and satisfaction. Accord is an agreement to pay off a debt with a lower amount. Satisfaction is the actual payment of the amount. So the accord is the agreement, the satisfaction is the satisfaction of it. It doesn't have to always be money, but it typically is. We understand modifications. Modifications, you do need consideration, unless it's the modern prevailing view, which says that if the modification is to remedy something that is unanticipated by the parties and is fair and equitable, then no consideration is needed. No consideration was needed at no consideration is needed between merchants under the UCC. Consideration is needed at common law, but there's also no consideration needed if it's to remedy something that's fair and equitable under the circumstances. So you have modifications, you have accord and satisfaction. One other thing I'll talk about contract law, just to keep the wheels turning, would be parole evidence. And the main thing they test when it comes to parole evidence is that oral evidence or extraneous evidence can come in not to contradict, right? That's the parole evidence rule. That can't come in to contradict, but it can come in to show a condition to contract, to show a defect in formation, to show additional terms, to show customer trade usage, or clarify ambiguous terms. These are reasons why parole evidence can come in. So that's a lot about contracts. Contracts, it's a tough subject, especially on the MBE, because you got to be really focused on the details. On essays, I think it's a really manageable subject. With torts, I think the thing that you have to know about torts are like identify what the torts are: intentional torts, assault, battery, false imprisonment, trespass to land, trespass to shadows, conversion, intentional infliction of emotional distress, intentional interference with a business relationship, right? These are intentional torts, and you want to know that you need to prove that it was actually intentional. Whereas negligence, duty, breach, causation, damages, causation needs to be actual, the but-for cause, and the proximate, meaning the foreseeable plaintiff or within the zone of danger, right? All these elements need to be proven. First thing you got to look at is the duty. How is the duty determined? Well, who are they, right? Are they a kid? Well, they'll, kids in kindergarten, he'll be held to the standard of care as another kindergartner. If he's, Andrew, he'll be held to the standard of care as super handsome 35-year-old man, like whatever it may be. Would be the standard of care. I'm just kidding about the handsome thing. I know I'm muy feo, but it's just the concept that if you are an expert, you're going to be held to an expert standard of care. If you're a kid, you'll be held to a childlike standard of care, unless this kindergartner here took Heather's motorcycle and started riding around town with it. Then the kid would be held to an adult-like standard of care because he's doing adult-like activity. Don't let him ride any motorcycle. It's very dangerous activity, right? Speaking of very dangerous activities, in torts, we have this concept of strict liability. Strict liability applies for inherently dangerous activities. It applies for wild animals, and it applies in products liability. Products liability, the different theories they could bring for products liability are express warranties, meaning failure to warn or inadequate warning; a design defect, meaning that it failed the risk utility balancing test. The risk of designing it one way outweighed the utility of designing it the way that they did. The manufacturing defect, meaning that it was created or made differently than designed. And then the implied warranties, the implied warranty of merchantability and the implied warranty of fitness for a particular purpose, right? Make sure you can understand all those different concepts when it comes to a products liability case. A premise liability case is when there's like a slip and fall or a land related incident. And it's a duty, breach, causation, damages discussion. Just determine if they're a licensee, an invitee, known trespasser, unknown trespasser, and determine what duty of care is owned. Another thing related to my man, the kindergartner here, is what if he's walking down the street and he sees a broken trampoline in Tommy's yard and he goes and plays on it and hurts his thumb? Well, that's what's known as an attractive nuisance. So he would actually be held to the standard of care as an invitee, someone who should have been warned of these unknown dangers, or warned of these potential dangers. So those are some concepts in torts. Also, defamation, recognize that if they are a public plaintiff, you need to show actual malice. That's a key factor, right? If you weren't negligent, you didn't know, like you had no knowledge of its falsity, then there's no malice and you won't be able to prevail against a public plaintiff. There's slander per se, which occurs for crimes of moral turpitude, loathsome disease, unchastity, and about a person's business. These would all be times that we would say it's slander per se. Res ipsa loquitur, the thing speaks for itself. Look for it being under the exclusive control, right? That instrumentality, the scalpel left in the body, or the pot that fell off the balcony. Understand the differences between pure comparative negligence, no matter how liable you are, you can still recover, versus modified comparative fault, which if you're over 50% at fault, you cannot recover. And then contributory negligence, if you're any percent at fault, assumption of risk, that's a complete bar to recovery. So these are some really important concepts that you should understand in torts. And I think in torts generally, if you're writing an essay, throw the kitchen sink at the reader. Talk about all the potential torts, IID, NIED, now I'm never going to be able to look at the moon again because of what happened yesterday. Like all these claims could potentially come in. If you're doing it on a MBE question, then put yourself in the shoes of the injured party and be like, how should they recover here? How did they get injured and what's their most actionable claim, right? Be careful, readers, read the call of the question. If they say, can they prevail in a claim for negligence? You're looking for a breach of duty of care. If they say, can they prevail in a claim for IIED? You have to look for something that gets to the element of intent, right? So make sure to match up the answer choice with the question, the claim, put all the facts together, be very careful and methodical. All right, that takes us to the Constitution. Constitution, I ask people, you're taking a bar exam, you might see me in Tampa. Don't come too close, right? I might ask you what's the 10th Amendment to the Constitution, right? Like, this is war. I want to make sure you're ready for this. I'm not going to send you off to battle if you haven't even, cleaned up your artillery. Like, we have to be sharp, right? You have to know the amendments to the Constitution. Don't you dare take this test without knowing the first 14 amendments to the Constitution, right? I feel like this kindergarten kid can name a couple of them, right? It's not that hard, right? First Amendment, freedom of speech, freedom of religion, freedom of press, freedom of petition, freedom of assembly. These are fundamental rights under the First Amendment. There's some types of unprotected speech. Is Andrea here? Yeah, you're going to see her album release party this weekend. I think you're going to understand that art is art is protected. Obscenity is not. Hate speech, defamation, false or misleading commercial speech, right? These things are not protected speech. Freedom of religion, that's free exercise and free establishment. If it's content neutral, it could be like time, place, and manner restrictions. These are, considerations of the First Amendment. Second Amendment, the right to bear arms. Third Amendment, Vicky G is not here, but I think she was violating the Third Amendment from what I understood, which is sheltering a soldier during a wartime. The Fourth Amendment is the right against search and seizure, unreasonable search and seizure. So you need a warrant, then you're to be probable cause. Exceptions to the warrant requirement, I use the spaces mnemonic: search incident to arrest, plain view doctrine, automobile exception, consent, exigent circumstances or hot pursuit, and the stop and frisk doctrine, right? The Fifth Amendment, there's 5 things tested on the Fifth Amendment. 5 key things: due process, so that's notice and hearing. Pleading the Fifth, meaning your right against self-incrimination. The takings clause, meaning that the government cannot take private property, exercise eminent domain or condemnation without just compensation. There's the right against double jeopardy, meaning that you can't be charged of life or limb for the same crime twice. And then there's your Fifth Amendment right to counsel. We call that the Miranda rights, that if you're in custody where a reasonable person wouldn't feel free to leave, then you have to be apprised of the right to remain silent, the right to an attorney. If you cannot afford one, one will be provided for you, and that anything they say can and will be held against them, right? These all come from the Fifth Amendment. Due process is the big one. The Sixth Amendment is your right to counsel after adversarial proceedings have begun. So we can differentiate Sixth Amendment and Fifth Amendment right to counsel, because Fifth Amendment was you're in custody. Sixth Amendment is after charges have been filed. Your right to speedy trial and the Confrontation Clause. The Seventh Amendment is your right to trial for, it's your right to a jury for issues at law, if there's monetary relief, or if it was, actionable by a jury, or it gave rise to a jury at common law, like a writ of ejectment, or if the statute tells you, or the fact pattern tells you that they had a jury at common law. But typically, it's for legal issues, and if there's a jury and a non-jury, equitable issue, you always have the jury trial first. So the Eighth Amendment is against cruel and unusual punishment. The 10th Amendment is state sovereignty. So that means that states police themselves. It implicates the anti-commandeering clause, meaning that the federal government cannot force the states to enact legislation. They can use what's known as conditional funding. They can induce but not compel, meaning, hey, Louisiana, we're not going to give you funding for your highways unless you raise the drinking age to 21. Well, shit, we got potholes. We got to raise the drinking age. That's okay. But they can't say, hey, Louisiana, you must raise the drinking age to 21. That would be commandeering. So I like Jonathan. The Ninth Amendment of the United States lists certain rights in the Constitution that does not other rights that people retain. It just, the Ninth Amendment really applies the constitutional rights to individuals. I skip it because it's impossible to be tested. The Third Amendment, the Ninth Amendment, and the 12th Amendment are pretty impossible to be tested, but whatever. But appreciate that. The 11th Amendment, so the 10th Amendment is state sovereignty. The 11th Amendment is sovereign immunity. Sovereign immunity means that individuals cannot sue the states, although they can sue a state actor in their individual capacity or sue the state for injunctive relief. And the states cannot sue the federal government, although the federal government can sue the states. So, you see me in Tampa, hey, Andrew, what's up? Yo, what's the difference between the 10th and 11th Amendment, right? That's the type of shit that's on my mind. 10th Amendment is state sovereignty. 11th Amendment is sovereign immunity. 13th Amendment is, freed the slaves and prohibits discrimination based on race in private places as well as public places. And then the 14th Amendment, heavily tested, is equal protection, and even includes due process on Section 5. But equal protection under the 14th Amendment is where we get the suspect classes, race, alienage, national origin. But remember, alienage, if it's related to government functioning, like serving on a jury or being a police officer or a public teacher, then it's rational basis. But alienage, otherwise is strict scrutiny. Race, national origin, right to work, right to be a candidate, right to travel. These are all things that are going to implicate strict scrutiny. It must be necessary to achieve a compelling government interest, and the burden of proof is on the government. Intermediate scrutiny, which is typically applied to gender or illegitimacy, is the government has the burden of proving that the legislation is not substantially related to an important government interest. And then rational basis is the plaintiff has the burden, and the very difficult burden, of showing that it's not reasonably related to a legitimate government interest. So those are the different standards of review under equal protection. The difference between equal protection and substantive due process: equal protection is targeting a specific group of people, whereas due process, substantive due process, is a deprivation of the people's rights, liberties, or property. 15th Amendment is, prohibits discriminating based on race when it comes to voting. 16th Amendment is about taxing and spending. 19th Amendment is finally when we gave women the right to vote, I believe. And other than that, the amendments aren't too important. But not that they're not important, but not too heavily tested. So anywho, you should really be sharp on 1 through 14 when it comes to the amendments to the Constitution. Understand the Commerce Clause, that the Congress can regulate the channels, instrumentalities, and economic activities that in aggregate have substantial effect on interstate commerce. And the Dormant Commerce Clause, the negative implications of the Commerce Clause, which means that states cannot discriminate against interstate commerce, nor can they enact legislation that unduly burdens interstate commerce. You look for separation of powers, the legislative branch, the judicial branch, and the executive branch. Make sure you keep them separate and know, what the different powers of them are. I like vet caps for the executive branch, the veto power, the exclusive representative of foreign affairs, the treatise power, the commander in chief, the appointment and removal power, pardoning power. And remember, president for federal crimes, not state crimes, governor for state crimes, not federal crimes. And then I guess the State of the Union address or something of that nature. I mean, these mnemonics all mean things to different people, but that kind of helps me keep some of those pieces straight when it comes to Constitution. Constitutional law can be very difficult. If you're taking Florida, there's a whole nother lens you have to be able to look through. And make sure you're sharp on that. Kind of just leads me right into Crim Pro, because Crim Pro is Fourth, Fifth, Sixth Amendment. I already talked about those things. Just look out for the exclusionary rule. Look out for the fruit of the poisonous tree doctrine. When you're in custody, you're not in custody when you're just being pulled over at a traffic stop. They can tell the passenger to get out of the car. They can do an inventory search of the car. It really is going to come down to probable cause and Miranda rights and, maybe Sixth Amendment right to counsel and things like that when it comes to criminal procedure. When it comes to criminal law, it's a lot like torts. You have to just know the crimes, right? Murder is heavily tested for sure, right? When it comes to murder, we have common law, premeditated, cold-blooded, malice aforethought murder. Then we have three other forms of murder. Murder when a killing occurs during the commission of an enumerated felony. We have murder when it's with a depraved heart, so indifference towards human life. And then we have murder that occurs when someone intentionally inflicts great bodily harm on another. So inflicting great bodily harm, depraved heart, felony murder, and premeditation are four different forms of murder. Voluntary manslaughter is adequate provocation, walking in on the pool boy with your wife, or imperfect self-defense. Someone slaps you and then you stab them back. Involuntary manslaughter is criminal negligence, speeding and hitting someone, texting and driving and hitting someone. Those are things that can constitute involuntary manslaughter. You got to know the specific intent crimes. And when it comes to the specific intent crimes, I think the best mnemonic that we came up with was even a student can fake a laugh for ridiculous bar facts, embezzlement, burglary. No, I'm sorry. Embezzlement, assault, and assault is like, in the majority of jurisdictions, solicitation, conspiracy, fraud, larceny, first-degree murder, robbery, burglary, and like fraud or forgery or whatever. The whole arson one, kind of, some people say it's general, some people say it's specific. It's really malicious, which can be, or reckless. So I guess it's technically not specific, but I still kind of think about it a little bit differently than some of the other crimes that are purely general intent. And then there's the bar arc, not bark, bar arc. That's a homage to somebody. And that means that there's burglary, arson, rape, robbery, and kidnapping can be underlying felonies for felony murder. Got to understand the concept of merger, where some crimes can merge into others. Like, a larceny will merge into robbery because larceny has all the elements of robbery. Robbery just has one additional one. Or the inchoate crimes, solicitation and attempt will merge into the greater crime. Attempt is also a specific intent crime. So maybe that's what the A comes from in the mnemonic. Attempt, think about it. It just has to be, did you attempt to do it? Did you try to kill the person? Even if he was already dead, you tried to kill him. Even if you didn't, think of attempt as a, unsuccessful. You tried to do it, but it didn't go well. That's attempted murder. Whereas murder is the actual killing of that person. So, theft crimes, larceny, larceny or larceny by trick or false pretenses. Distinguish larceny by trick and false pretenses, because larceny by trick, you just get possession, whereas false pretenses, you actually get title to the thing. Just kind of transitioning into real property. Real property is a tough subject. Some key pieces are like, what's a mortgage? A mortgage is a loan secured by property. If you expressly assume a mortgage, then you become primarily liable, and the original party is a surety, secondarily liable. If you take a mortgage subject to, then you become secondarily liable, and the original party stays primarily liable or personally liable. There's different types of tenancies. There's a JTROS, a joint tenancy with right of survivorship, where if one party dies, the other party will take on the property, or a tenancy in common, which is presumed, where if one party dies, then that party's heirs will take their share of the property. And then tenancy by the entirety, which is a JTROS plus the element of marriage. Assume on the test a lien theory state over a title theory state. A lien theory state means that an encumbrance on the property will not sever the JTROS. And if one party takes a mortgage out, who's a JTROS, and then they die, the lender cannot recover from the other party because it was only a lien on the property and it wasn't a title to the property. There's the concepts of fee simple determinable, fee simple subject to condition subsequent, and fee simple subject to executory interest. Fee simple determinable uses durational language, so long as, until, while. And if the event happens, so long as alcohol is not sold on the premises, the second time you start serving drinks there, it's going to revert back to the owner. And remember, in real property, the owner could be that person's dead and now it's his son. That person's dead and he gave his estate to charity. Now it's the charity. The owner means the estate, whoever, will step into those shoes. So fee simple determinable means it's automatically going to revert. Fee simple subject to condition subsequent means that upon a stated event, but if this happens, then the owner has the right of reentry, meaning they could come in and take, and then executory interest could be shifting or springing. A springing executory interest springs from the grantor to the new party, the grantee, whereas a shifting executory interest will shift from the third party, the grantee, to a new third party. So A to B, but if B, goes to Ohio State, then to C, it shifts from B to C. To B, if B graduates from college. B, it springs from owner to B. So springing versus shifting. Rule against perpetuities. No interest in land is valid unless it must vest, if at all, within 21 years of the death of a life and being at the time the interest was created. Andrea, not to give away the surprise, but the sexy octogenarian is coming down Santa Claus Lane. That's one of her albums where she shows off, the fertile octogenarian, or I call it the sexy grandma. The concept where grandma conveys property to any of her sons who reach the age of 30. She's got a 31-year-old kid. That's going to violate the rule against perpetuities. Why? Because it's possible the next year the 31-year-old kid dies. The year after that, sexy grandma goes on Hinge and pops out a baby. Year after that, popping out a baby was a little rough for grandma. So now she's passed away. So now what do you have? You have a baby who's living. The measuring life has died. And is it possible within 21 years, we're going to know if it's going to vest or not? No, because that baby has to reach 30 and it's a 21-year period. So in that situation, that part of the conveyance would violate the rule against perpetuities. If that went all the way over your head, I'll give you an easier one. If there is a right of first refusal, that'll violate the rule against perpetuities, meaning if A transfers the property B with the condition that, but if B ever decides to sell it, then A gets to buy it for the market price, right? Or for the first 10 years, A gets to buy it before B can sell it to anyone. That clause right there violates the rule against perpetuities. I don't even need to explain to you why, because it's so complex that it would scramble all brains right now, but it's a fact, right? Here's another fact if you're taking the MBE. A deed in lieu of foreclosure will not eliminate junior mortgages. At some point when you're taking a multiple choice test, just remember a lot of right answers. And when in doubt, it's probably that one. Like a estoppel by deed, right? That's the concept where A is going to get the property in the will. A knows you're going to get the property in the will, and A conveys it to girlfriend. And girlfriend's like, ooh, kissy, kissy. And then A's like, yes, amazing. And then let's say the mother dies. Now A gets the property, but by this time, girlfriend has already moved on to, NFL player. And now A is like, hey, I got to convey this property to my new girlfriend. So A wants to convey property to new girlfriend. The problem is A already conveyed it to previous girlfriend, even though A didn't have the authority to convey it then. But once A got it via the terms of the will, when the mother died, it automatically activated the earlier conveyance. Or a way of thinking about it, A is stopped from denying the earlier conveyance. So that's estoppel by deed, meaning like if you convey property you don't have the authority to convey, the moment you have the authority to convey it, you'll be stopped from denying the earlier conveyance. So in that situation, Casey girlfriend is actually going to be the one with the property. When it comes to real property, mortgages, there's a concept of a foreclosure, which is the forced sale of the property to pay back the mortgagees. It'll go to pay back the senior mortgagee first, and then junior mortgagees obviously after that. And if they can't get enough money from the sale of the property, they'll need to seek a deficiency judgment from the person themselves. The mortgagor, the person who's, the property is being foreclosed upon, they may have the right to buy back the property before the sale. That's known as an equitable right of redemption. If they have the right to buy back the property even after the sale, that's known as a statutory right that's known as a statutory right of redemption. There's the concept of adverse possession in property, which means if you take a property and you squat on it and it's open, continuous, exclusive, adverse, notorious, and hostile for the statutory period, then you can take title to that property. There's also things known as easements in real property. Easements are a non-possessory right to use property. They're like a right of access or right of way. Easements can be expressed, they can be implied. Easements can be affirmative or they can be negative. Easements can be appurtenant, tied to the land, or they could be engrossed, which means personal in nature. Easements can be by prescription, which is similar to adverse possession, but no element of exclusivity. So open, continuous, adverse, notorious, hostile for the statutory period. Or there could be what's called an easement by necessity, which means that an easement arises because a property is so hemmed in or it has no access to a public road that there needs to be a way to cross over it, right? The concept of merger comes up at least twice in real property. Once is in that very scenario where if A has a property, Green Acre, and B has a property, Red Acre, and there's an easement across them, right? But then A buys Red Acre. So now A has Green Acre and Red Acre. It is said that A has merged those two properties. So the easement between them no longer exists. It's terminated. Now, if A were to convey this part of the property again, that easement would have been terminated. It's pretty hard to terminate an easement, but that's one way that an easement could possibly terminate is through merger. How else do we see merger? The concept that a contract merges into a deed, right? So when a contract is signed, it will merge into a deed, so you won't be able to sue on contract claims once the deed has been recorded. A question I ask people, you come to me right now, you come to me on the day of my daughter's wedding, and trust me, if I don't look at my phone right now, but look, Alexis already texted me. People want to do sessions with me right now. And I tell Alexis, hey, if the check clears, I can get a session in, but charge them my highest rate possible. And they don't even care because they haven't been properly prepared. The test is coming up. And just like Meryl said, well, I said about Meryl, we have the secret sauce. So when people come to me, they sit down and all they want to know is the one golden question that they'll pay me any amount of money to answer. Am I ready to pass the test? Right? If I can answer that question, how much money would you pay me? That's, and I'm like pretty freaking good at answering that question. If I never met you before, I'm going to ask you one question. What are the 6 warranties of a general warranty deed? If you fumble and bumble that up, I'm like, yeah, your odds aren't looking good. If you sit there and you just stare at me cold in the eye and you're like, oh, easy. A general warranty deed, there's 3 present warranties and there's 3 future warranties. The present warranties are sizing, the right to convey, and the right against encumbrances. The future warranties are general warranties, further enjoyment, further assurances, and quiet enjoyment. Fuck, I stumbled and bumbled it. Right now, I'm just kidding. So let me do that again. The 6 warranties of a general warranty deed are the right against encumbrances, the right to convey, and sizing. The future warranties are further assurances, general warranties, and quiet enjoyment. And so if you can understand those 6 warranties of a general warranty deed, you're in a pretty good position to pass the bar exam because that's not a common thing. Nobody on earth would know that unless they were studying for the bar exam or were a real property attorney, right? So that's the level of depth you need to know on this. So the, general warranties, the different warranties of a general warranty deed, different types of easements, the difference between a covenant and an equitable servitude. Equitable servitudes are remedied by injunctive relief, whereas covenants are remedied by legal relief. They're, monetary damages. Real property, super difficult subject. If you're not doing well in real property, we have this one sheet in the classrooms that's called the real property vocabulary sheet. Highly recommend you just go over that and you see a word that you've never seen before and you're like, turn that into a word that you know. Like, I mean, this might be con law, this might be real property, but these are some vocab words for zoning: non-conforming use, variance, and amortization. A non-conforming use means you've been grandfathered in to doing something differently than zoned for. So they changed the zoning, but you're allowed to continue doing what you were once doing. That's a non-conforming use. A variance means you're permitted, you get a permit to do something differently than you're zoned for. That's a variance. And then amortization means you're going to slowly conform a non-conforming use over time. So, the more vocab words you know, the better you should be able to do. All right, we're getting down to the pretty wire, the wiry wire. What about evidence? Evidence comes down to hearsay. When I took my first bar exam, I walked out of there and I said, man, I wish I was able to pay someone $1,000 before I took this to tell me if I was going to pass or fail, because I have no idea, right? And I wasn't sure. And I thought if I failed, the reason is because I didn't understand murder that well. There were so many questions like, is this second degree or third degree murder? I'm like, I didn't even know there were degrees of murder. Like I thought, I didn't even know what murder versus manslaughter meant, right? Like I come a long way. And then the other piece was hearsay. I had no idea what hearsay really meant. Like my instructor, Michael Graham, was amazing at teaching torts. He was terrible at teaching evidence, right? I did not understand hearsay at all. So y'all should really understand what hearsay is. Hearsay is an out-of-court statement proffered into evidence in order to prove the truth of the matter asserted. So hearsay is, we don't let hearsay in because it's that he said, she said, it's not reliable. We don't know. Like, of course, you bringing in a statement where Tommy said he didn't do the murder. Like, that's very convenient for Tommy, right? But there are a lot of hearsay exceptions and exemptions, times where, it will come in. And it's also important to note that of these exceptions, there's times where unavailability is required or where unavailability is immaterial. So hearsay exemptions, I mean, I don't want to confuse people because Florida, California, they kind of messed this up. So let's not even go down that route, but just understand the main difference between a statement against interest and a party opponent admission is a statement against interest requires declarant unavailability, right? Learn all these exceptions and exemptions, like the learn treatise, learn the, business records, excited utterance. These are all different types of hearsay exceptions that should come in. So when you're confronted with evidence, first ask yourself, will it survive the 403B balancing test? Meaning, is it relevant? And evidence is relevant if it has any tendency of fact to prove or disprove a controverted fact, or any tendency to prove or disprove a controverted fact that would make it relevant. And is it reliable? Reliable meaning that its probative value is not outweighed by its prejudicial value, right? If you're in California, you have Prop 8, but same kind of understanding that like, it can't be overly prejudicial. So that's the first thing. Is it reliable? Is it relevant? And then you kind of want to decide like, is it hearsay? Is it being something we can bring in substantively, something we can bring in to impeach? What's really going on here? You can usually bring in to impeach for bias. That comes up a lot. Like the person saying the statement works for the department who is on the other side. That might be an issue. You should understand the mimic concept, where we're not going to bring in specific acts to show propensity to commit a crime or to do something bad, but we will bring it in for any other reason, for motive, for intent, for mistake or lack of mistake, for identity, for common scheme or plan, for consciousness of guilt. These are reasons that we actually could bring the evidence in. Most jurisdictions use the Daubert standard for determining if an expert witness is qualified. Recognize as a key answer on the MBE at least that preliminary questions of admissibility are for the judge, not the jury. The jury determines the weight of the evidence, whether the evidence is admissible or not is for the judge to decide. And usually the judge should, consider the evidence outside the presence of a jury and can take in consideration of anything, hearsay, whatever it may be. Grand jury trials are to determine probable cause. They're secretive. The rules of evidence do not apply, but there will be, the right to plead the fifth or something of that nature. Evidence, I think it's a pretty tough subject. It could be cheeky. If you're a Florida MBE student, it's the hardest subject by far because of the distinctions between Florida and federal evidence and keeping them straight. And I'm not going to go over them now because I don't want to confuse only MBE or California students. But as you're coming down, to the wire, I was listening to Merrill. Merrill said a lot of great things, right? I love what Merrill had to say. The only thing I would add to it is sharpen up the dates and times and distinctions and things like that, like things that you don't want to mix up on test day. You shouldn't really be learning what negligence is on Sunday, but maybe you should be learning, wait, is Florida's modified comparative fault, and on the MBE, I assume pure comparative fault. What are you know what I'm saying? Like little distinctions and differences. Florida is 120 days to file the complaint. MBE is 90 days to file the complaint. Like, we have lists for them and definitely sharpen them up. Unless I'm mistaken, I think one of the last main subjects that brings me to is civil procedure. Is there any other subject? I mean, besides essay subjects and things like that, I hit them all, right? I did contracts, I did torts, I did con law, I did real property, I did evidence, I did crim law, I did crim pro. It just so happens my last finger on my count is the middle one, right? I'm not flicking y'all off. I was just literally counting 1, 2, 3, 4, 5, 6, and that brings me to civil procedure, right? Fuck civil procedure. Tough subject. Let me give you some interesting points to learn. Claim preclusion versus issue preclusion. Claim preclusion is the actual claim, right? The same parties, the same configuration. We can't bring it again. And privies for claim preclusion usually mean an employer or an employee or something of that nature. Issue preclusion, which is collateral estoppel, claim preclusion is res judicata. Issue preclusion is more narrow. It has to actually be adjudicated, right? Like, the issue was actually litigated, and we will allow non-mutual issue preclusion if the jurisdiction allows it, which means another party to assert it. Claim preclusion is always mutual. Issue preclusion could potentially be non-mutual if the jurisdiction allows it. Offensive versus defensive means like plaintiff asserting it versus defendant using it as a shield. These are some concepts of claim preclusion and issue preclusion. The Erie doctrine means that if we are in a diversity case, we will use federal procedural law and we will use substantive law of the state where the federal court is sitting. We will also use that state's choice of law under Claxon if the question calls for it. So federal procedural law, procedural is like order of witnesses, procedural is like rules relating to venue, just rules and regulations. Substantive is like elements of the case, elements of murder, elements of negligence, or damages, or statute of limitations, or things like that. So make sure you understand the difference between substantive issues and procedural issues under Erie. Remember, if it's in federal court for a federal question, then it's not a diversity case, and we'll use federal, procedural, and substantive law. Some key things to understand are standards of review and standards for judgments. Like summary judgment means there's no genuine dispute of material fact. JMOL, renewed JMOL, or in states like Florida called a directed verdict or belated directed verdict, or JNOV, means that no reasonable juror could find for the non-moving party. And then a new trial, we're looking for the verdict is against the weight of the evidence. If there's something that's being brought like 6 months, 8 months later, it's probably a relief from judgment, which can typically be brought a year later, up to a year later, and except for some circumstances, it can be brought at any time. Civil procedure, super difficult subject, personal jurisdiction, bringing us back to 1L year, right? They have, the minimum contacts consideration, general versus specific jurisdiction. They can be, PJ can be because they're served within the state, because they're domiciled within the state, or like I said, they have minimum contacts. SMJ, that's the $75,000 or more and complete diversity to get into federal court. And then venue is where the cause of action accrued, where any of the defendants reside if they all live in the same state, or if none of them are applicable, then where they would have personal jurisdiction over any of the defendants. It's a really, really difficult test. I could go into a lot of weeds with civil procedure. I'm trying to think about like what's tested on essays, multiple choice, because California and UBE, it's essays. Florida, it's multiple choice. MBE, it's multiple choice. I mean, it's all pretty similar. I think the last thing I'll leave y'all with is the 12B defenses. 12B1, SMJ can be brought at any time, right? A motion to dismiss for SMJ can be brought at any time. 2, 3, 4, and 5 need to be brought at their first opportunity, which means, the answer, the pre-answer reply, when it first became available, and then you replied to it, like whatever it may be, the first opportunity, yours forever waived. That's PJ, venue, service, and process of service. And then 6 and 7 can be brought, anytime throughout the trial, like until the verdict is reached, but not on appeal. Like SMJ can even be brought on appeal. But 6 and 7, 12B6 is failure to bring a claim for which relief can be granted. And 12B7 is failure to join a necessary, indispensable party. What that means, necessary, indispensable party, necessary means that, we're going to join them if feasible. And if it's not feasible, then we need to determine if they're indispensable. If they're indispensable, it means that in good conscience and equity, the case can't proceed without them. So we'd have to actually dismiss the case. The difference between impleader, intervention, and interpleader: impleader is bringing someone into the case, right, by filing a claim, a third-party practice, impleader claim. Intervention is a third party intervening, stepping in. And then interpleader is a plaintiff filing an interpleader against multiple defendants, forcing them to determine like who owns the property or who may be liable or something like that. Look for, Rule 11 violations for, ethical rules or like them, frivolous complaints or things like that. Remember the safe harbor provision where the attorney needs to give them time to amend, but sua sponte, the court is allowed to move on its own. One little thing is the only way to amend a final pretrial conference order is to prevent manifest injustice. And the reason I end with that word manifest injustice is you're probably like, how did he know that the way to amend a final pretrial order is to prevent manifest injustice? And because my man EJ, I'm about to call up and see if he wants to go to the Tampa Bay Lightning game with me Tuesday night. He was a former student of mine, and he submitted his rap album. That was his rapper name, was Manifest Injustice, and his album title was Final Pretrial Order. And those things do work. So you have until midnight to submit your albums. I'm going to do the album reveals tomorrow at my classes. Hopefully it'll be a lot of fun. And I really, really appreciate everyone for hanging out with me. I told y'all I'd finish strong. I would put my best foot forward to end. I think I did a pretty decent job of hopefully you learned at least, just one thing in my final lecture. But really, really appreciate everyone for hanging out with me during the boot camp. The first year of the boot camp, we were the Eagles, right? Because eagles are the highest flying bird. If an eagle is flying as high as possible and it sees another bird, it must be another eagle. So that's kind of what I wanted the group to embody. The second time I did the boot camp, it was the buffaloes, because the purpose was when the storm is coming, the snow is coming, the cows, they go the opposite way and they get stuck in the storm. Whereas the buffalo, the bison, actually face the storm and they go through it. And by facing the storm and conquering their fears, they actually get through the storm a lot quicker. So I think that's a good way of like, let's take this test, let's face this test, and let's conquer it. And then last administration, the spirit animal was the lion, the apex predator, pretty self-explanatory, the king of the jungle, like just go out there and, take care of business, pretty vicious. And then this year, it was the wolf. And the wolf is an incredible, also apex predator, really meaningful for me because, as y'all know, I lost my dog just at the beginning of the bar prep season, and I love dogs. And I love that when people say, oh, he's got that dog in him, or yo, that's my dog. Like, dogs are my favorite animals. I love dogs. But I read this book called The Rise of Wolf 8 and then The Reign of Wolf 22. And you could learn everything about the universe from how wolves operate in a wolf pack. They're very playful, they're very loving, but when it comes time to take care of business, especially the alpha male or even the alpha female, whoever it may be, a lot of times it is the alpha female because the alpha male got killed or whatever, and someone needs to step up, or whoever it may be. Maybe it's one of the younger ones, but whoever needs to step up when it's time to step up. They really take care of business. They provide for their entire family. I have a lot of admiration for the wolf. So that's kind of how I want everyone to feel like on test day. Like, you're going to take care of business, for whatever reason, it's all left up to you, and you're going to go out there and get the job done. So I really, really appreciate everyone for hanging out with me during this boot camp. I'm going to go ahead and stop this recording.